Today's video is based upon a wonderful blog posting by eminent family law attorney Lee Rosen. His blog post was entitled, "The Client is Backing Out of the Deal," and this is the link to his original blog post shown below. We have mandatory mediation in our state. I'm a fan of mediations and find they work really well if everyone is prepared for them. In preparation for the mediations, I prepare a full shell or outline of the settlement agreement and sit down with the client to go over each area we're going to try to resolve: custody, property division, alimony, attorney's fees, etc. I explain the process and the mediator's style. I try to get the client ready as much as possible. Yet I have noticed a phenomenon at the end of the mediation. Even if the client is fully prepared, and even if he or she has participated in the mediation all day long and has been heard, even if all issues are addressed and resolved, when the agreement is finally printed, and I am almost always the one that writes it, which is fine with me, and the client is reviewing the agreement, he or she unravels. The tears start coming and the person starts freaking out about minutia or starts bringing up random add-ons. For example, this week a client started crying and debating whether she had to pack a toothbrush for her 2-year-old in addition to clothing. This was an educated client. It's not unusual for clients to say, well, he or she is getting everything he or she wants. It's not unusual for such a statement to be completely untrue as well. Whether it's the loss of control or the knowledge that the litigation will end or fear of missing out or missing a crucial issue, these episodes of cold feet and anxiety can deprive you of a good settlement and a waste of all your time and money getting there. I concede that mediations like this are not uncommon, however. The parties come together for a single day. They often go to separate rooms, a setup of which I am not a fan. They spend all day negotiating with the mediator, shuttling back and forth. Then after everyone is tired and worn down, if you and your attorney are fool enough to do that and go till 11 o'clock, a deal is struck. The documentation is prepared and signed and the case is closed. The mediator is happy because the case was resolved. The lawyers are happy because they're finished with their clients and won't have to deal with them any further. However, the clients aren't always happy. In fact, they're sometimes very upset. They have emotional outbursts or they go home and have second thoughts. It's more common than not that they express some regret about the deal. If I had my druthers, we wouldn't sign the deal the same day it was negotiated. We'd mediate, sleep on it, and sign it after lawyers had a chance to get it documented properly. And the parties have a chance to reflect on the deal. Some of the clients would back out after changing their minds, that's true. But it's the objective to make the deal, or is it to deliver the process that people need? Is the objective to make the lawyers and their mediator happy, or is it to make the client happy? Some lawyers argue that getting to resolution is good for the client, and I agree. But at what cost? Is settlement worth the strong-arming that often takes place by the lawyers and even sometimes by the mediators? Is it worth damaging the relationship? Is it worth diminishing trust? And here's the reality, at least in my experience. The mediations that unravel and don't get signed shortly after mediation get signed eventually. Mostly, these clients come to an agreement after some time passes. They may not have been emotionally ready the first time around. They may have a need for more processing, more thinking, and going through the process of grieving. You know, the denial, the anger, the bargaining, the depression, and acceptance. That's life. A lawyer's or mediator's decision to rip the Band-Aid off, even if made with benevolence and well-intentions, can often be totally unnecessary and even counterproductive. Bottom line, and you know that's where I live, I'm not sure the quick settlement is good for the client or the attorney. Getting to the finish line at all costs or at almost all costs may not be worth it. Sure, if a client wants the deal done that night and that's the client's priority, then go for it. But if the lawyer's eagerness to settle gets pushback, then it's worth considering why the lawyer is pressing his client to get it done. Is it for the lawyer or is it for the client? So back to the bottom line. If you want a settlement that is fair, complete, understandable, doable, and enforceable, one that your client accepts without reservation, I'm not sure that 11 p.m. settlements shoved down the client's throat are the way to get there.